All rise. Veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Good morning, everybody. Court officer, please call the case.
Thank you, Mr. President. The situation in the Democratic Republic of the Congo in the case of the prosecutor versus Affaire Ntaganda. Case reference, ICC 0104-0206. We are in open session.
Thank you, court officer. Today we are going to hear a remainder of the defense closing statements. It should be completed during this session by 11 o'clock. So, Mr. Bougon, it will be, I guess it will be you? Oh, still, Mr. Gosnell. Okay, we'll continue. Sorry. Mr. Gosnell, you have the floor.
Good morning. Thank you, Mr. President. Good morning, Your Honors. Yesterday, I left off with the submission concerning counts 6 and 9, suggesting that there were no facts and circumstances defined in the document containing the charges on which you could properly enter a conviction under Article 74(2). And we make the same submission in part in respect of counts 14, 15, and 16. Because there can be no denying that the last two sentences of paragraph 95 of the document containing the charges do plead with sufficient particularity, we say, the facts and circumstances of where Mr. Ntaganda purportedly saw individuals who had been enlisted in the FPLC or UPC forces and who were being trained. And that includes, Mr. President, if you'll see, with reference to paragraph 95 of the document, the visit to Rwampara on the 12th of February 2003. However, aside from those last two sentences of paragraph 95, the DCC does not provide any adequate facts and circumstances to enter a conviction. In particular, in respect of recruitment, at paragraphs 93, 94, where aside from the broad temporal scope that is set out therein between August 2002 and into 2003, and then paragraphs 96 and 97, in respect of the use, alleged use of child soldiers. There's nothing in the nature of these crimes that excuses the failure to set out the facts and circumstances with adequate particularity, including, for example, where the recruitment took place, when it took place, where was the use, who was recruited, who directly performed the recruitment. Paragraphs 92 through 99 simply do not provide adequate particularity in these regards. And this was not an issue, Mr. President, that was in any way litigated in the Lubanga case. As you know, Your Honors, there are other facts and circumstances that also are not pleaded with adequate particularity, and those are set out at paragraph 14 of our reply brief. And of course, none of that in any way is with prejudice to Your Honor's own independent analysis of what you consider has or has not been adequately pleaded in the document containing the charges. This brings us now, Mr. President, to the question of the evidence concerning child soldiers. And I propose to address this evidence in the following 5 sections. First, the direct child soldier witnesses themselves, the observational and hearsay evidence, as we've defined those terms in our brief, the videos purporting to show individuals under the age of 15 within the ranks of the FPLC. Fourth, the documentary evidence. And finally, Mr. Ntaganda's knowledge. Obviously, this discussion will be selective rather than comprehensive, and we, of course, rely on our submissions in our brief and reply. But the question that hangs over all of this evidence is, where are the credible and reliable child soldier witnesses? The problem is not that no one was willing to come forward and say that they were a former child soldier with the FPLC. We know that because of the 16 individuals who put themselves forward as such in this case and in the Lubanga case. And none of the 12 who testified in the Lubanga case were deemed reliable or credible. 3 of those 12 were found to have lied at various times in respect of their age. And 3 intermediaries were found to have encouraged lies by those 12 individuals to such a degree of certainty that the trial chamber recommended that the prosecution pursue Article 70 investigations against those individuals, which, as far as the public records of this court show, have never come to fruition. And we say, Mr. President, and we think that the evidence shows abundantly clearly, that the 4 child soldier witnesses who testified in this case, or perhaps 5, depending on the prosecution's current position in that regard, were manifestly unreliable. They were not only unreliable, they were quite simply untruthful. And not only untruthful, but in the case of 761, 883, and 888, they were fabricators of documents. And not only did they lie and fabricate documents, but in the case of 758, 761, 888, and at least 898, and 911, these witnesses coordinated their testimony to give a false impression of reliability. And these are serious allegations, Mr. President, but they're abundantly supported by what you witnessed in this courtroom when these witnesses testified. Now, if these witnesses had testified in public session, which they did not, I would have replayed for you some of the extraordinary examples of these witnesses' untruthfulness and fabrication of evidence. I would have played P883's reaction when she was confronted with the original version of a document that she quite obviously had herself tampered with in order to give an impression of her age to the court. I would have played the moment when she displayed an amazing facility in French in respect of a rather complex document, I suggest, Mr. President, after earlier in her own testimony, in respect of a much simpler document, asking the prosecution to read it because she claimed she couldn't read French. I would have shown you 888's reaction when he was showing his baptismal record, showing that he was 4 years older than he was claiming in his testimony. I would have shown you a few examples of 761, unrepentantly and shamelessly lying in front of your honors about his role in putting forward 758 as a child soldier with the FPLC. His lies about where she was born, his lies about where she grew up, his lies about whether he had any role in obtaining documents immediately after 758 had been rejected initially by this court as a child soldier with the FPLC. But these would just be sensationalist highlights, Mr. President. What really matters is the careful analysis of the many, many contradictions in these witnesses' testimonies about where they were, what they did, whether they were ever with the FPLC, and when they were born. And all of those contradictions and inconsistencies are discussed at length in the brief at paragraphs 1165 through 1282. These were not isolated glitches of memory caused by the passage of time or the frailties of recollection. We're talking about testimony that was manifestly false. We're talking about efforts to make the testimony appear more reliable through efforts in intervening years since the events, sometimes recently, we suggest, to produce false documents and to coordinate testimony. It's very difficult to believe, and I say this even with respect to the testimony of the late Dr. Ewell, it's very difficult to believe that the testimony even could have been the result of false memories, let alone merely unreliability. So the real evidential difficulty for Your Honors in this case is not that no witnesses were available. On the contrary, an abundance of alleged child soldier witnesses have been available. It's just that they either lied or were not reliable. Now this brings us, I suggest, immediately to the second category of evidence, because the two...
Sorry,
Yes, Mr. President?
President, if you allow, I would like to put you one additional question. Does the defense have any theory what could be motivation for those witnesses to lie?
That's a very good question, Mr. President, and I did think as to whether I should address Your Honors on this question. I can speculate, I can suggest many reasons. Those of us who've spent time in Ituri probably know some of the reasons, and there will probably be different interpretations of the potential reasons.
I am not insisting, no
yes,
problem.
Thank you, Mr. President. But it does raise an important question, because what I suggest is that it's not really for us to speculate about these issues, but you nevertheless deal with them by asking yourselves first whether or not the evidence that you've seen is or is not reliable, and that's the primary basis for you making that assessment. But the question that you've just asked is a very important one, because what it really points to is, why is there the need to ask that question? Why is there a lacuna, a gap, in the evidence that has been brought into this courtroom to be able to allow Your Honor to know the answer to that question? And this really does bring us back to the burden of proof. And the burden rests on the prosecution to make sure that the question that you've asked is a question that you're able to answer based on what was heard in this courtroom. And we say that that's not the case. So this brings us back to the second category of evidence, which is a disparate mass of evidence that does indeed concern different types of information, including interviews of purported former child soldiers, witnesses who saw subjects in the FPLC whom they visually estimated to be under 15, and in a few cases, knowledge of subjects who they claimed were in the FPLC, but age was known on the basis of some prior association or a family relationship. In her dissenting opinion in the Lubanga case, Judge Usachka expressed her hope, quote, that future prosecutions of these crimes at the court will adduce direct and more convincing evidence and preserve the fairness of proceedings which lies at the heart of criminal prosecutions and should not be sacrificed in favor of putting historical events on the record. Well, Judge Usachka's hopes have been disappointed in this case because fewer child soldier witnesses have been presented in this case than in the Lubanga case. And a greater reliance has been placed on the secondary evidence than on what we would describe as the primary evidence. And the lesson that seems to have been learned from the Lubanga case is not the concern that has been expressed here by Judge Usachka. The lesson that appears to have been learned and to have been implemented by the prosecution in this case is that it is better to bring fewer child soldier witnesses and better to bring less direct evidence, which has inherently lower probative value, but on the other hand is much harder for the defense to test and to attack and to show that it's not true. And why not, Mr. President? Because after all, that evidence was sufficient in the Lubanga trial chamber to carry the case over the line of reasonable doubt. And since this evidence, as I just said, is harder for the defense to discredit, why go to the trouble of calling more direct evidence that simply will be proven to be unreliable? And this really goes to the heart, Mr. President, of what we're doing here and what international criminal justice is about. How much will you bend the usual standards of proof that you expect in respect of a particular type of crime? How much will you accept, and this comes back to Your Honor's question, the unsubstantiated allegations or claims of security concerns or of re-traumatization that precludes evidence that you would expect from coming into this courtroom to be tested and to be witnessed by Your Honors? I recall vividly the moment when this argument of re-traumatization was raised during the proceedings as a reason not to put a photo board to a witness, suggesting that putting the photo board would re-traumatize the witness. An utterly standard form of cross-examination, a standard form of investigation, Mr. President, in respect of any serious crime. And that objection was rejected by Your Honors, but the mere fact that it would be suggested shows the point that we've come to in terms of cutting the corners on ensuring that evidence that is brought before you is reliable and can be tested, that you can know it's reliable because it has been tested. And just as Your Honors rejected that objection, we ask you likewise to resist the temptation to bend those standards of proof on the basis of any suggestion that witnesses are unavailable, that child soldiers who were reliable could not have been brought to court. I mean, those claims are facially contradicted by the 16 witnesses who have come to this court and whose testimony we suggest is or has already been found to be unreliable and untruthful. And the question is simply, if it's true that the FPLC was an army of children, if you couldn't throw a stone in Ituri without hitting an FPLC child soldier, then where is the direct evidence of these former FPLC child soldiers? Your Honors, in almost none of this evidence, this what we say secondary evidence, 3 subcategories of secondary evidence, but in almost none of this evidence were you given the names of the subjects who were said to be under 15 years of age. In none, or almost none of the cases, were you given a photograph of the alleged subject. In almost none of these cases do you have corroboration in any meaningful sense of that term, in the sense that you have two independent, separate sources describing or commenting upon the age of the same person. In these circumstances, Mr. President, it is virtually impossible for the defense to undertake any kind of investigation to determine whether or not this type of evidence is true, partly true, possibly untrue, highly likely true. These assessments are simply not possible. And we suggest they're no more possible for Your Honors. And for those few witnesses who did mention the name of the subject, the question that must be asked is, what was done to find those individuals? Why were they not brought to court as witnesses to testify before Your Honors? To say that, yes, I was an FPLC soldier and I was under 15 years of age at the time. Relying on this secondary evidence is not really or only a question about hearsay. It's a question about allowing substitute evidence, evidence as a substitute for the direct evidence that should be available, to be relied upon decisively in resolving these charges. We say that's unreliable, unfair, and does not meet the standard of proof that must be required by any criminal court. Now, if Your Honors were dealing with an issue of was it raining on a particular day, perhaps this type of evidence could be considered satisfactory. But a factual finding that a person is under 15 years of age, which is an element of the crime that Your Honors must determine beyond a reasonable doubt, is significantly different for three reasons. First, assessments of age are subject to a significant margin of error. It involves a substantial measure of subjectivity and opinion. And this is not reduced by resort to claims about methodology. Did the interviewer write the person's name down? Did they ask 3 or 4 questions? Did they ask someone else their opinion about the age of the person? None of that lends itself to any meaningful verification, and does not enhance the probative value of the claim. Second, this is a finding that must be made based on the standard of beyond reasonable doubt, unlike a contextual factor or a contextual issue such as was it raining on a particular day. And third, it's the evidence that you saw in court that should put you on alert that there is a serious possibility that that secondary evidence is not correct, that it's as unreliable as the direct evidence that you heard, and that it is hazardous in the extreme to rely on the secondary evidence as a substitute for the unreliable evidence that you heard in court. The unfairness, and I say the hazard of doing so, is increased by the fact that a large number of these subjects claim to have been under 15 years of age are individuals whose name the prosecution possesses and whose name was not disclosed to the defense. And let me just repeat that because it's so important, Mr. President. The prosecution possesses a large number of the names of the individuals whom they say are under 15 years of age and whom they ask you to enter a conviction against Mr. Ntaganda on the basis of. They have those names and the defense doesn't. And those names were also anonymous as far as the defense is aware to the trial chamber. So you have a witness appearing in court describing that someone else told them that they were under 15 years of age, the name of the source has not been revealed to your honors or to the defense, and that source is also the victim, and the name of that victim has not been disclosed either to the defense or to your honors. And let's be very clear about the nature, the characterization of that evidence. This is not evidence, this is not information that just falls under Rule 77 as being material to the preparation of the defense. It's hard to imagine information that could not be more relevant to assessing the credibility of prosecution evidence, which is the heart of Article 67(2) of the statute. Now, in fairness to the prosecution, it's not that they haven't disclosed it to us because they don't want to. It's not because they've hidden it away in a vault and we've subsequently discovered that it exists. It's not that, Mr. President. We're not suggesting that for one moment. It's that there are third parties who have placed a legal constraint on the information. The prosecution accepted that legal constraint in receiving the information, and therefore it has not been disclosed. But that is utterly irrelevant to the prejudice caused to this trial. And the prejudice, though not necessarily obvious, is insidious and wide-ranging. Did the prosecution seek out these individuals, having their names in its possession? If so, were statements taken? If statements were taken, have they been disclosed to the defense? Have their statements been checked thoroughly for consistency and on an ongoing basis to determine whether there are inconsistencies between those statements and any of the evidence that your honors heard in this courtroom? If there were any such inconsistencies, were applications made to the provider of the information for an exceptional disclosure to the defense to ensure that Article 67(2) was respected? Or did the prosecution simply undertake no investigations on the basis of this information? Did they conduct no interviews of such individuals? And if not, why not? There are so many ways, Mr. President, in which the unequal access to this information tilts the playing field, especially in respect of a charge like this, unfairly against the defense. And it's not a question, again, this comes back to your Honor's question. It's not a question of us needing to point out the potentials as to how in the field this might affect the fairness of investigations, the equality of investigations, the equality of what goes on in the courtroom. That's below the tip of the iceberg and not a matter that can be brought to your honors. What matters is that the rule itself is a prophylactic against those prejudicial impacts. And when the rule itself is violated to that extent, and the extent, to be clear, is massive, we are talking about a proportion of victims and sources saying that they were under 15 that is at least 17 times more than the number of child soldier witnesses who testified in this case. Now, the defense's position concerning P46 was misrepresented on Tuesday, suggesting that our position was that she was a liar or had coordinated with anyone in telling lies. And this is simply not true. And never has the defense given this impression. The defense's position is that her so-called verification of age amounted to nothing more than asking other individuals their opinion about those subjects' age. That this second opinion was only sought in very few cases, as far as the documentary evidence shows. That in almost all cases, the information about affiliation with the FPLC was hearsay. And not only hearsay, anonymous to the trial chamber and to the defense, all of which we say reduces this evidence's probative value to zero. It simply cannot be relied upon to any degree. I come now, Mr. President, to video evidence. Yesterday, the prosecution showed you some selected video clips from amongst those that they have tendered into evidence, presumably the clips that they consider the strongest in showing that there were individuals under the age of 15 with the FPLC, and all focus first on the question of those who were in uniform. And your attention was drawn, if you'll recall, to two individuals sitting on the back of a truck, wearing hats, a person who is getting into the back of a white vehicle at Wampara, and one other individual whom we see for an extremely brief period of time, whose face you can't see, and whose physique and size is assessed purely on the basis of their relation with others around him. Whatever initial intuition your honors may have about the age of these individuals has to be tempered by the following question, which we say reflects properly the well-established standard of proof, which is it unreasonable to say that those subjects might be 15 years of age or over? That's the test. Nothing less is required to prove beyond reasonable doubt. Now, if you look at the pictures in front of you, which of course are far more distinct, far clearer than any of the images that you have been shown by the prosecution, your initial reaction probably would be, well, it's quite clear that any and all of these individuals are over the age of 17. Surely they must be. Yet legal standards applicable in the context of asylum applications have commanded that, in fact, these individuals not be found in the eyes of the law as being older than 17. And when you're asked to draw a conclusion based on a brief and poor quality video image alone, the need for caution is even greater than applies in the asylum context, where individuals sit down face to face with an adjudicator, are interviewed, answer questions, and a decision is made about age. And the need for caution is enhanced not only by the fact that you're not sitting face to face with the individuals alleged to be under 15, but you're dealing with individuals of a different ethnicity, which was expressly cited in the Merton case from the United Kingdom as a reason for even greater caution in making judgments about age. And in this case, unlike in the asylum context, it's not proof beyond, on a balance of probabilities. It's proof beyond a reasonable doubt to decide that a man should be put in jail on the basis of your assessment of a 2-second clip from a video in which you can't see the face of the person, and that's going to be the basis to send a person to jail because they've used or conscripted child soldiers. When you're properly guided by these principles, Mr. President, I suggest that it is not possible to make a determination that the individuals who were pointed out to you on the videos are under 15 years of age. But more importantly, perhaps, Your Honors, is the fact that the isolation of these 4 individuals amongst all of the video evidence at the prosecution's disposal, especially when compared to the appearance of the scores of other FPLC soldiers whom you see in uniform in those videos, confirms that the FPLC was anything but an army of children, that it must have been applying a standard of age, and that even those who came even close to appearing to be under the age of 15 were not enrolled within the ranks of the FPLC as a matter of course, which is the prosecution's case. These isolated exceptions actually prove the rule that the FPLC must have been applying standards of age to ensure that child soldiers were not enlisted and enrolled. And the prosecution seems eager for you to overcome this problem, or possibly recognize it to some extent, in stating what you see on the page in front of you, which is, we say, an outright and blatant reversal of the burden of proof. They're asking you to say, in effect, I think, Mr. President, well, maybe there aren't very many people who appear to be obviously, or we say are clearly under the age of 15, but there are a whole bunch who appear to be in the age range of 16, 15, 17. Well, surely the law of large numbers means that some of them must be under 15. Entirely fallacious reasoning in a criminal case, Mr. President. It's not a basis, not a proper basis to conclude that anyone was under the age of 15. And it, in fact, implicitly recognizes that the prosecution knows that the very vast majority of the individuals who are visible on those videos are not even visibly, not even plausibly under the age of 15. Documentary evidence. And I come to the document of Mr. Adubango, a document on which such decisive reliance was placed in the Lubanga case. And so it's quite clear that the prosecution has known since the beginning of this case that it would place an equally heavy reliance on this document. And what this document actually says is that a program is being set up in favor of child soldiers aged 10 to 15 to 16 years. Now, the prosecution asserts and suggests to you that this is therefore a statement of fact about the nature of the ages of individuals in the FPLC. And obviously, since Mr. Adubango is the author of the letter, and since Mr. Adubango is in the FPLC, this document is being accorded particular significance because it is, in a sense, a declaration against interest. And it's also contemporary. So in that sense, the prosecution cites this document as being a matter of particular probative value. But what you don't know is whether Mr. Adubango ever visited an FPLC training camp. You don't know who was the instigator of this DDRRR program that he is discussing. And we suggest you don't know why he adopted this age range. Was he intending to offer a description of the actual ages in the FPLC? Or was he seeking to avoid that anyone from anywhere, from any armed group, should be excluded on the basis of age? Now let's look at a few documents, Mr. President, that might shed some, albeit limited, light on this question. Because we say that the obligation of shedding light on those questions and answering those questions was on the prosecution. And the prosecution could have shed light on those questions by asking questions to witnesses about this person, by calling this person, for example. We don't say that the conventional rules of authentication of documents apply in this courtroom, but Your Honors do need information about who created the document, what was the basis of their information, what did they mean to refer to, especially when it's a document on which such heavy reliance is placed. And what we suggest is that, in fact, there are other reasonable interpretations of the document because, in fact, this document appears in a line of documents that address demobilization not from the FPLC, but demobilization from other armed groups and from self-defense forces. And we know that these self-defense forces continued to exist even after the existence of the FPLC, and that at times they were a problem for the FPLC. And here we see the document from Kisembo of the 30th of October 2002 indicating to sub-commanders that you must disarm all children under the age of 18, even in the auto defense forces. 10th December 2002, Thomas Lubanga. What we see in this document, and we can turn to the next page as well, is Thomas Lubanga on 10 December expressing concern about a large number of weapons circulating amongst the civilian population, which he believes to be a threat to security, and calls for a census and registration of such weapons as soon as future municipalities are pacified and interethnic conflicts have been suppressed. 10th of January 2003. Here we have the UPC again calling for the dissolution of the Comité de Paix, noting that they are not following the UPC-RP's ideology and are undermining pacification. And let's remember, this is just a little more than 1 month before the Adubango document. And what these documents show is that the self-defense forces were in existence to some degree at least, that the FPLC and the UPC were trying to bring these self-defense forces under control, that the FPLC and the UPC were trying to disarm these groups, and that indeed there would have been a need for a demobilization program to those ends. So to easily look at the Adubango document and say, well, this must be a factual description, a factual statement that there were child soldiers in the FPLC as young as 10 years of age, may be one possible interpretation of the document, but it's certainly not an interpretation that can be said to be the only reasonable interpretation. And we say that that is the high standard that Your Honors need to apply to that document, because we suggest it is a matter that you would place almost decisive reliance upon in order to come to this conclusion. And of course, this is where the prosecution undoubtedly will respond, but there are other pieces of evidence that confirm that there were children under the age of 15, or suggest that there were children under the age of 15 in the FPLC. And so that this is really no more than one card in a deck of 52. And that you can assure yourselves that that's what the document meant. And we say that that reasoning is wrong. It's undoubtedly true that you must address yourself to the totality of the evidence. But what is wrong is to say that every piece of evidence is equally relevant or equally probative of every other piece of evidence. And I say that because we have the principle of corroboration. And corroboration, we say, requires a degree of convergence in the fact that needs to be proven, and a degree of independence of the sources. We don't say that it's more than a question of degree. We don't say that it's not a question of fact. We don't say that Your Honors don't have a wide range of discretion in determining what is relevant, what piece of evidence is relevant to establishing the reliability of another piece of evidence. But what we do say is that if you set your lens at the level of just saying, well, does this prove the charge? If you say that P46's documents are probative of this document, then that is an error. That is a mistake. Because then you're essentially abandoning the requirement of analyzing to at least some degree the appearance, the independent appearance of reliability and probative value of individual pieces of evidence. And we say, Mr. President, that this document, this Adubango document, is not meaningfully corroborated. It's not meaningfully supported by the circumstantial evidence that you would expect to see for such a major claim as the fact that there were a factual claim that there were 10-year-olds in the ranks of the FPLC. I come now to Mr. Ntaganda's knowledge of children under 15 in the FPLC and the prosecution's submission on Tuesday at page 31 that he testified inconsistently in saying on the 27th of June that the primary focus of evaluating age was physical testing instead of the questions asked to the subject. Whereas after the summer break, he purportedly said it was obligatory, and this is said to have been a major change. The prosecution ignores, however, that on the very next day, after the 27th of June, before the summer recess, Mr. Ntaganda offered a further explanation of the testing and how the testing fit in with the questions to the witness. And that's at transcript 214, page 33, line 12. And we say that that shows that, in fact, he was not thinking about the answer to give over the summer recess in order to make it look better. In fact, when you see the answer, you'll see that it appears to be, I suggest, a genuine and spontaneous explanation of how asking the question about age fits in with the physical evaluation of a person's age. And lest it be suggested that it is implausible that recruits would show up and not know their age or give the wrong age, I direct Your Honor's attention to paragraphs 31 and 32 of the child soldier's brief, which I assure Your Honors the defense has read assiduously, which refers to an electoral law which states, and I quote, and I'll speak a few words in French, si la personne ne connaît pas l'année exacte de sa naissance, l'agent inscrit celle qu'elle croit l'être. So if the person doesn't know the exact year of birth, not just the exact date, the exact year of birth, it will be up to the official to make a visual assessment, I assume, and write in the name. That's the extent to which this phenomenon is a reality. It had to be incorporated into the law that an official could do this. The prosecution asserted on Tuesday at page 84 that 13 witnesses saw Mr. Ntaganda using children in one capacity or another. The 13 weren't identified. I can only assume that they're referring to P901, who testified that Mr. Ntaganda's bodyguards were approximately 14 or 15, that they intend to refer to P55, who said that only some may have been 14 or 15, and P290, who said that the individuals whom he rejected from training at Ntaganda's residence were 15 or so. They've also apparently neglected to mention D17's testimony that none of Mr. Ntaganda's bodyguards were below 16 or 17. D251's testimony that his youngest escort was 16. And we say, Mr. President, in fact, that the conflation of the word, or ambiguous use of the word children, as often referring indiscriminately to those below and above the age of 15, is one that was not only to be seen in the prosecution's submissions on Tuesday, but in fact often throughout this case. And we suggest that Your Honors need to be cautious in that regard. Prosecution also said on Tuesday, quote, "The accused also admitted to UN officials and to a researcher that P315, and to a researcher that he knew that there were children amongst the UPC." This is absolutely wrong, unless you interpret the word children as meaning anyone under 18, because that's all that P315's evidence showed. And if the prosecution is referring to P31, his testimony was contradicted by P46, the person to whom P31 said Mr. Ntaganda was speaking. And P46 said that that never happened. P190's lurid testimony about Mr. Ntaganda storming into a classroom in Mutsapela should be accorded no probative value. It was contradicted by D57, totally uncorroborated. This is an event that surely many witnesses would have seen if it had occurred. The Rwampara video of those in civilian clothing and the prosecution's reliance on parsing words of Mr. Lubanga to suggest that every last person at the assembly must already have been accepted for training. The exact words of Mr. Lubanga cannot possibly bear such an inference. They do not contradict Mr. Ntaganda's and D80's account that some of those individuals had just recently arrived at Rwampara and that he instructed that they be rejected from the training. And even P30 confirms that some of the individuals there that day were, and I quote, "civilians who want to join up." That's DRC OTP 2054-2951 at page 2981. Paragraph 33 of the prosecution reply goes even further and says, quote, "Everyone at the Rwampara training camp was either a soldier or a recruit. Ntaganda testified to that effect," unquote. That's a bald-faced misstatement of the evidence, Mr. President. I invite Your Honors to look at what the prosecution has cited in support of that claim at footnote 132, and you'll see the extent to which what I've just said is correct. So the prosecution's suggestion that the Rwampara video proves to you that Mr. Ntaganda blithely accepted anyone of any age into the ranks of the FPLC is, we suggest, unsustainable. It's certainly not proven beyond a reasonable doubt. It's not even a reasonable inference based upon the information that they've given you. And more generally, certainly Mr. Ntaganda admittedly had something to do with training in the FPLC, but that doesn't mean that he had comprehensive knowledge of every last recruit in every training center, or even necessarily in every unit of the FPLC. And we say that that's a further important consideration for Your Honors. Last point on child soldiers. What is the status of the Lubanga judgment in this case? Well, Mr. President, you know that under Article 21, of course, it's of no relevance. Its findings are not in any way binding or even a matter for Your Honor's guidance. Of course, none of us in this courtroom, not a single participant or neither party has been able to resist the temptation to delve into the Lubanga judgment in various ways. But I'll say only this about the Lubanga proceedings, and that is that I suggest for anyone who reads the trial judgment or the appeals judgment, you will see that the evidence came out in a very different way than it has in this case. And that is what primarily calls for Your Honor's entirely independent and unaffected judgment and assessment of the evidence in this case without regard to the findings in the Lubanga trial chamber. And the Lubanga appeals chamber made very clear that it was applying the traditional appellate standard of deference in assessing the correctness of the trial judgment. That means that the appeals chamber could just as easily have upheld an acquittal as a conviction in that case. And the notion that the appeals chamber has resolved all aspects of the correctness of the trial judgment in terms of factual findings is incorrect. Just a few words on the second attack, Mr. President. The factual foundation of the so-called crime base in respect of the second attack. Under normal circumstances, there is no doubt that the testimony of a dozen or so witnesses at a large-scale event such as the massacre at Wadza would be sufficient to prove those events beyond a reasonable doubt. But that evidence was nevertheless tainted by a host of anomalies, including the forensic evidence that showed that there was no sharp force trauma on any of the bodies that were exhumed at the site, contrary to the preponderance of the evidence of the witnesses who said that in fact individuals had been killed with machetes or with bayonets. The inconsistent and, I must say, puzzling stories about the origin of the photos, the discrepancies as to the number of victims and cited by witnesses and the numbers of remains found at the Wadza site, the close contact of many of the witnesses whom you heard with one another. And even though it's true there is one item of clothing from the photograph that does bear a striking resemblance to one of the items of clothing that was exhumed at KOB1, it must also be said that there is no other item of clothing, and some of them are quite distinctive, visible in the banana field photograph that were found in the exhumed graves. But even assuming that you find there was indeed a massacre, a series of killings of some extent at Wadza, it's important to recall that that occurred on the last day of the KBL operation. It was not part of a pattern of mass killings or massacres, and the prosecution implicitly tried to suggest otherwise by relying on the testimony of P863 about the alleged massacre of 6 individuals in the hospital at Bamboo. And we say that that testimony must be rejected entirely. The prosecution provided no explanation as to why 863 would not have described such a gruesome event in his first statements to the prosecution, nor why no forensic evidence was adduced, even though 863 identified the exact location in relation to the Bamboo Hospital where he said those victims were buried. The available video and satellite imagery shows, Your Honors, that the testimony of many witnesses about a scorched earth policy being adopted by the soldiers of the FPLC is simply not true. Lipri appears virtually untouched, despite the testimonies of P127 and P317, and in fact even the reference in P317's report that Lipri had been destroyed. And we say that the photographs of many other locations show the same inconsistency with other testimonial evidence. Mr. President, on Tuesday, the prosecution offered some clarity as to the events for which it seeks convictions in respect of sexual enslavement. we say that providing this information on Tuesday raises serious questions about adequate notice. I also can't help but refrain from observing that the three individuals whom P790 overheard and for whom the prosecution apparently seeks separate convictions for this crime might well be P18, P19, and P113, which means that the prosecution is asking for a conviction for the same event twice. In conclusion, Your Honors, the evidence of the second attack does not show that it was a scorched earth operation. On the contrary, the evidence shows that in general it was an operation that was pursued lawfully and against lawful objects of attack. And even assuming that that crime at Wadza occurred on the last day of the attack, that doesn't change that general picture. Your Honors, I thank you for your attention. That concludes my remarks, and I now pass the baton back to Maître Bourgon. Thank you.
Thank you very much, Mr. Busnell. And now we can move to Mr. Bourgon. Mr. Bourgon, you have the floor.
Thank you, Mr. President. For the next 60 minutes remaining in our time, I will address witness credibility issues, the responsibility or alleged responsibility of Mr. Ntaganda pursuant to Article 25, and I will say a few words with respect to Article 28. I'm reminded to call for the control to be passed over to this side of the defense bench so that we can operate the PowerPoint presentation, please.
Court officer, please assist.
Three issues related to witness credibility. First one is applicable factors. The second one has to do with insider witnesses and, of course, other OTP witnesses. Demeanor in court, of course, is an important consideration for the chamber in assessing credibility. But there are a number of other factors which need to be assessed by the trier of fact in determining the reliability of evidence provided by a witness. All of these factors have been set out in our defense closing brief as well as in our reply. I'll take only a few minutes to address some of the criteria addressed. First one is the role of the witness. The role of the witness is very important, and I said so before. Depending on his or her position and seniority, it can be expected or not expected on the part of a witness to have certain information. For example, a junior witness or a low-rank individual is not expected to be privy to conversations, decisions, plans involving senior officers. Does that mean that it's not possible? No, it is possible, but it is a consideration. Let's take, for example, witness P907. Very little, if any, military background. He's a bodyguard. Now, if a witness like P907 testifies about issues that a normal bodyguard would not have, then it should attract the attention of the trier of fact and at least ask how was that information obtained. Is it normal for such a witness to have such information? Now, in the case of P907, it's quite different from the issue of D17, also a bodyguard, but a very close bodyguard working very close, first with an individual called Safari, and secondly with an individual called Bosco Ntaganda. Second factor, corroboration. The prosecution points out in its the closing brief that corroboration is not a requirement. They are right. It is not a legal requirement per se. But when the testimony of a witness raises doubt when it is questionable and we can't understand that testimony, then corroboration becomes the key. And in the absence of corroboration, very often, the trier of fact will be led to the conclusion that the evidence is not reliable. A witness, when a witness is the only one to provide evidence on a specific issue, that in and of itself should attract the attention of the trier of fact, at least to be cautious about his evidence. For example, P17 was the only witness who testified about orders allegedly given by Bosco Ntaganda to fire on civilians from Sayo. When we look at the context in which this evidence is provided and the fact that he is the only witness to provide this evidence, this in itself raises serious doubt. P894 is another one, the only witness who testified that he is present amongst a group of individuals during which Mr. Ntaganda would have committed not one, not two, not three, but 4 murders in front of his eyes, that he would have pierced the eyes of someone before him, that he would have continued the conversation with the man who had his eyes pierced, who said, "Why do you do this to me?" And this individual would have seen all of that at a time which does not match the evidence, and he would have simply left without no one asking him any questions about what he had seen. That kind of information, Mr. President, requires corroboration. And it brings the issue even more important in assessing credibility, which is that of plausibility. What is plausibility? Well, there is a test that we suggest to you, Mr. President, is accepted. This comes from a British Columbia Court of Appeal decision where there's a test suggested to look as to what is possible or not possible. And I need to read that test. In short, the real test of the truth of the story of a witness in such a case must be its harmony with the preponderance of the probabilities which a practical and informed person would readily recognize as reasonable in that place and in those conditions. Applying this test to the evidence of many of the insiders leads to the conclusion that their evidence is simply not plausible and not reliable. What is important, and what is the main issue, Mr. President, is what do we do with a witness who provides some evidence that is reliable and some evidence that is not reliable? Is it possible? Yes. Is it accepted? Yes. Well, how do we determine? Well, we say that when a witness is caught lying, one lie suffices in raising and requiring the very careful attention of the trier of fact in assessing his testimony. Now, in cases such as this one, where witnesses do not testify about a single event, they testify about a number of events over a long period of time, it is possible sometimes for a witness to lie or to give false evidence on one single issue and then give the truth on other issues. That can happen. And it is the duty of the trier of fact to try and determine which part is correct and which part is not correct. But there is one overlying consideration, and that is when a witness will lie or fabricate incriminating evidence. That's the difference. When a witness fabricates incriminating evidence, then all of the incriminating evidence he provides thereafter cannot be said to be reliable. Why? Because if I lie about one issue that I put on Mr. Ntaganda's back, that is not true, and then I also say I testify about 5 other issues, it is simply not possible to determine which of these issues is true or not. and it has to be disregarded and set aside. Because filing or fabricating incriminating evidence is the worst case scenario for a witness. And that, Mr. President, we say should guide the trial chamber's attitude in looking at the evidence. Moving on to insider witnesses. We mentioned in our brief a number of them who are unreliable. For example, I have a list here: 907, 768, 17, 963, 901, 190, 55, 16, and 10. Prosecution mentioned 16 insider witnesses. There's a list of more than half of them, we say, did not provide reliable incriminating evidence. The list, I could add and increase this list. These are just the main ones which we say the trial chamber must pay particular attention. And, Mr. President, I must add, two unreliable witnesses together don't make a reliable witness. This is not mathematics where you got two negatives that make a positive. It doesn't work this way. All of these witnesses, Mr. President, we say provided false incriminating evidence. And in that respect, their testimony should be disregarded. I'd like to look at a few examples with the chamber this morning, beginning with P907. We identify the manner in which P907 moved from being a potential defense witness to a prosecution witness. I'm not going to say more about this. But in the sense of the manner and the testimony of 907 as to how he would have participated in the FPLC's first attempt to go to Mongwalu and the FPLC's second attempt to go to Mongwalu, his testimony in this regard, when you look at the cross-examination, is simply not credible, not possible, and cannot be given any weight. I just recall the witness testified that he was with Mr. Ntaganda fighting in Mwanga just before the second FPLC attempt to go to Mongwalu. Well, at that time, the troops who fought in Mongwalu, they were in Lalu, so he can't be at two places at the same time. I also recall the witness saying that in order to go to these to the first FPLC attempt, he simply left his position as a bodyguard without being noticed by anyone, went to participate in the attack, returned using a taxi. And then after using the taxi, he returned, he joins back the bodyguards, and nobody asks him a single question. Mr. President, when you read that evidence and you apply the test I referred to earlier, it is clear that this man was not participating in the two FPLC attempts to go to Mongwalu. P907, however, is a witness who was chased from Mongwalu. He knows the situation in Mongwalu, and he has described it. So here's a case where you have non-incriminating evidence, which is reliable because he was there, and we know he was there. And he described the conditions in which the people who were there, I was going to use the word I was looking for the word. It's so horrible that I even forget the word. Cannibalism going on in Mongwalu. He described that. He described who in his own family was eaten in Mongwalu. So he knows about that, and his evidence is reliable. Because that situation in Mongwalu, that is why Thomas Lubanga requested FPLC to go there in the first place. I move to P768. There are so many issues involving this witness, I don't know where to begin. I will say, however, that significantly, when we look at the defense closing brief, as well as our reply to the prosecution brief, you will see, Mr. President, that many of the issues raised were not responded to by the prosecution. Mr. Ntaganda, I hear on the radio, is going to place some mines. The mines are placed. The mines are placed all around Mongolu in every single exit. The mines killed many, many civilians, women and children. Those who are hit by mines, they call me and I go and I pick them up with my car because I'm the only one to have a car. I pick up the victims. I bring them to the hospital. This is an horrible situation. I asked Mr. Ntaganda to take away the mines, but he refuses. Now that is very, very incriminating evidence. Now this witness, well, he forgot about all of that until the eve of trial. He said, I had other things on my mind. This is a witness, Mr. President, who had many dealings, volunteered to be a witness. His purpose in life was to come forward with incriminating evidence. He forgot about all of that. He remembered that on the eve before trial. And we did in our brief say, prosecution couldn't resist. Now we have him. So we'll get that evidence on the record. Mr. President, is there any doubt in anyone's mind that this is not an issue that anyone could forget and not bring in a statement before the eve of trial? I don't think so, Mr. President. Especially that he's the only one. Nobody else talks about anti-personnel mines in Mongolu. No record of any victims being killed or being injured by anti-personnel mines in Mongolu. No other witnesses talking about mines being placed at every exit or entry point in Mongolu. So where does that come from? Mr. President, it is clear fabrication, and a witness who fabricates this type of evidence cannot be true, cannot say the truth in terms of incriminating evidence. I could go on and on with P768. I will simply say one more, which is, of course, I mentioned it yesterday, the evidence about NZB. We have an FPLC operation, and the FPLC operation did not envisage any actions being taken in Zibi. He's the only witness who talks about Zibi. Where does that come from? Even those reports to which are not reliable and bring all the by themselves. Witness to say that. Where does that come from? He says he could look in the church and that he could see the people. But when the chamber will read the cross-examination I conducted of the witness, it is clear at the end he says, well, really, I don't remember anymore. Because he did not see anyone in the church. And again, the only witness. Now, if we look in those reports that we've mentioned as having no probative value, the Ituri Curse of Gold or Ituri Covered in Blood, or those reports, they do cover this incident about the church. Not with any kind of detail provided by P17, but the issue of the church is mentioned, and it is mentioned in a circular fashion. It's taken in one report and then circulated in the other reports. And we say, Mr. President, that must be where P17 got his information, because he's the only one, simply not plausible based on his testimony. Now, P17 also says that he was at the apartment where he saw prisoners being killed. Well, we explained in the defense closing brief that he could not have been at the apartment with Mr. Ntaganda based on his evidence. Mr. Ntaganda left Mongwalu. We know when Mr. Ntaganda left Mongwalu, and P17 was not there with him. And we've explained why in our defense closing brief. And it's not only related to the appointment of the commander of the Southeast Operational Sector. It is a major event, but it is much more. The evidence is much more than that to show that they were not together at that point in time, and that he fabricated, Mr. President. Now, he also said that he participated in the second FPLC operation, or the second attack as charged. Now, in this second attack as charged, if we look at P17, I've mentioned yesterday P17 saying something about radio conversation VHF between Kisembo and Salumu. Well, we say that in and of itself was not possible from a technical point of view. But there's also another issue. And I tried to ask questions for the witness, but I was stopped from doing so. Is it really plausible that a witness would every night go and spy on his commander? What were his this evidence. Now, P being interviewed by a man who has been jailed. Not true. He was not there, Mr. President. How would anyone allow an uninvolved witness to attend such an interview? I put questions to him in this regard. P963 is also the only witness who said that Salomou went and participated in the peace negotiation. Only witness. All of the evidence provided by P963 that is of an incriminating nature, Mr. President, must be set aside. P901. P901 is a close associate of Bosco Ntaganda for a long time. P901 said that Bosco Ntaganda was the most respected officer in the FPLC. P901 remained with Bosco Ntaganda when many others decided to join the National Army. He remained with Bosco Ntaganda because he was a close associate of Bosco Ntaganda. P901 corroborates Bosco Ntaganda's in many respects, and the Chamber should keep those aspects of his testimony. However, and then, of course, his testimony is very important because it does support the theory of the defense that knowledge regarding the so-called or the alleged crimes committed in Kobu were not distributed or were not known by many people. Mr. P901 I mentioned yesterday, so I'm just going to recall his testimony concerning looting of Mr. Ntaganda in Mongolia. Simply incredible. P190. My colleague addressed P190 with respect to certain issues. I will limit myself to one main issue, and that is the issue of his testimony related to an incident in 2004, which is not charged. Incident where he says that Mr. Ntaganda would have murdered a MONUC observer. Mr. President, I, on purpose, on cross-examination, and the Chamber will be able to see, I gave him all the rope I could give him. Give us some details. And he gave us some gruesome details about Mr. Ntaganda's involvement into an incident which is clear-cut because that MONUC observer he was referring to did not die anywhere close to an incident described by P190. Mr. President, a witness was willing to come and to describe before the chamber how Mr. Ntaganda would have killed, murdered, cold-blooded, with a gun, coming out of his truck and shoot between the eyes a MONUC observer. And it's entirely false. Well, Mr. President, issues like that show that this witness should be investigated for Rule 70. We did request that to the Chamber already. The Chamber said it was premature. We hope that the prosecution will see to it that this witness is investigated. P55.
Sorry, just one remark. Maybe you monitor that I had to sign two orders for reduction because you twice mentioned some details which could reveal identity of witnesses. Please be careful about that.
I see what's going on, Mr. President, and I apologize because I did really prepare my notes to avoid, and I will be even more careful to avoid identifying anyone. P55, I will simply again reiterate that is evidence regarding his telephone conversation with Bosco Ntaganda by Touraya simply deconstructs his testimony, and that the testimony he provided regarding the fact that he would have obtained information by MONUC persons and that he would have on this basis spoke to Mr. Ntaganda, all of that, Mr. President, we say is not true. And I will limit myself at this to avoid mentioning any details which could identify him. With respect to P16, I mentioned already that he had a family relationship with the person who was executed as a punishment. Now, P16, it is important to know that he was not in Mongwalu. He left Bunia and his job that he was occupying at the time before Mongwalu. He was not involved in the second operation to open the road, and all of his testimony is hearsay. We said that before. P10. Well, we provided many details about P10. We simply say that P10 was not abducted by the FPLC. The evidence reveals she was a former member of the APC. We know she lied about her age. The prosecution at some point during the pretrial proceedings said that the prosecution did not intend to rely on P10 as someone aged below 15, but yet now is taking a different approach. She did not participate in the second Mongwalu operation, second meaning the one that took place in November. And the prosecution referring to the to the testimony of D17, which by lapsus made a mistake, is incorrect, Mr. President. P10 was not raped. Where she said that she was raped is a time and place where Mr. Ntaganda could not have been. That was raised in cross-examination. She's been contradicted by many witnesses, including in respect of her presence in Rwampara. Third issue is other prosecution witnesses, and I will move straight to two witnesses very quickly because they were mentioned by the prosecution. P886 is a witness where the evidence he provided in chief was very different once cross-examination had terminated, in terms that he was not in no longer in Sayo when FPLC troops entered Sayo. That's a major difference. That's between his chief and cross-examination. He had left before. The timing of his return to Sayo is also very important. Now, witness P886 is the caretaker. He's the guy who finds body all over the place and he buries them. I'm not sure what I said that was wrong this time, but
I think I don't want to focus attention of the public to those
Okay.
things, but it's a minor fact, but still.
So the caretaker, well, the caretaker, Mr. President, I invite you to look at one incident which is revealing, and that is the incident of a number of persons allegedly found in the health center, which he found and which he buried himself. Just looking at this evidence is revealing. As for P894, well, other than the fact that Mr. Ntaganda is not charged with the murder of an individual called Lucella, I mentioned earlier why his testimony is not reliable. A quick word on dual witnesses. We describe in our closing brief as well as in our reply why the victim application form is relevant and important and why it must be assessed. Now, we have the utmost of respect for all victims. There have been many victims in all the events which took place in Nuturi over the years. Mr. Ntaganda referred to that when he spoke at the beginning of the case. But when a witness, victim or not, is going to file an application to be a participating victim and say A, and then will show up and testify to B, then the A and the B must be assessed by the chamber. I'm not going to say more about this issue. Mr. Ntaganda's responsibility for the first and second attack. So I start with the first attack. And what is significant is that at the moment the first attack as charged began, it is the defense submission as explained yesterday. There was no policy within UPCRP or FPLC to commit attacks against any civilian population. There was no ongoing Article 7 attack against the civilian population, and there was no common plan to commit the crimes alleged therein. The factual issues related to the first attack, if I need to recall a few, is that Mr. Ntaganda was appointed commander of the FPLC second operation. His involvement in that operation, we had two brigades. One commanded by Salumu coming from Mandro, and the other commanded by Sei coming from Aru. Mr. Ntaganda traveled to the area where the operation took place along with P290, arriving when the fighting had ceased. Mr. Ntaganda personally commanded the operation in Sayo. Again, it has to be recalled. He did not try to move away or to evade from this. He said, not only did I command the operation, I took personal control, personal command of Sayo. In Sayo, there was no destruction. And there was no destruction either of the church or any other building. Mr. Ntaganda described how the B-10 was used, what the B-10 produced for a result, and when he went up there, what he saw and what other witnesses saw. When the Sayo operation was over, the population started to return to Mongwalu at the request of the FPLC. Then Mr. Kisembo arrived with his delegation, and they visited the area. And Bosco Ntaganda returned to Bunia 2 days after the arrival of Kisembo. The prosecution said in its submissions that it is unbelievable that there was no one left in Mongwalu by the time the attack was conducted. Well, we did not say that there was no one left in Mongwalu. What the evidence reveals is that as soon as the first shots were fired, those who wanted to protect themselves, they left Mongwalu. Now, the persons remaining in Mongwalu at that time, they fall in two categories. People who are fighting or people who are hiding in their houses and seeking protection, and they were not hurt. So the status of the persons, whatever persons was remaining in Mongwalu, their status makes it that there was no attack directed at civilians or civilians not taking part in hostilities, which had a different status. The responsibility pursuant to Article 25, when we look at Bosco Ntaganda, our submission is that he did not commit any crimes personally. The manner in which the attack was conducted, both in Mongwalu and Sayo, is not an attack directed at civilians. There was no destruction either in Mongwalu or Sayo, including the church. There's no discrimination issue. FPLC wanted everyone to return. There was no murder of the Abbé, even though this is not even part of the conduct of hostilities. It is a charge, but there is only the evidence of P768, which is absolutely not reliable. And there was no pillage by Mr. Ntaganda in Mongwalu, contrary to the testimony of P901 and witness P768. Was there a common plan? 25.3a common plan? Well, no common plan to commit any of the crimes charged. And I refer the chamber to my colleagues' the argument and submissions regarding what must be in the common plan. What is the legal law applicable to common plan? In any event, there was no mens rea on the part of Mr. Ntaganda regarding Mongwalu, either in the first or the second degree. Was there any order issued by Mr. Ntaganda? Yes, there were. He did order issue in respect of Mongwalu. He was in command. He did issue orders in respect of Sayo, but there was no crime committed. No crimes were ordered. He did not order the commission of a crime. And even if the trial chamber would find that a crime resulted from his order, there is no mens rea of the second degree. There is no dolus directus of the second degree. And as for the 25.3d, of course, it's different from 25.3c, aiding and abetting, which is not charged. But there was no common plan and no dolus directus of the second degree. I move to the second attack as charged. Well, what was the situation in early February 2003? It was described in detail yesterday. There was no policy either within UPCRP or within FPLC to commit attacks directed at any civilian population. There was no ongoing Article 7 crime against humanity attack, and there was no common plan to commit any of the crimes charged or included in the common plan. Of course, Mr. Ntaganda is not charged as a direct perpetrator for the second attack because he's not there. So there was no charges for his personal involvement. What about under 25.3a for indirect co-perpetration? Well, first, there was no common plan, as we mentioned. And secondly, even if there had been a common plan, there was no contribution. We submit, Mr. President, regarding contribution, that the Chamber could look at contribution from three different aspects: before the second attack, during the second attack, or after the second attack. Mr. President, we say that in all 3 points of view, there was no contribution on the part of Mr. Ntaganda. The prosecution, in its closing brief, focused on planning because Mr. Ntaganda would have participated in a meeting long before the second attack. Well, what's the evidence on his contribution or participation? It's kind of limited to the testimony of P55, which we say is unreliable, and to 2 messages in the logbook, which have been explained in detail, not only in the testimony of Mr. Ntaganda, but also in our argument. It is significant crimes and did not order any issue which led to the commission of a crime. And should the trial chamber find that some crimes were committed, they are not the result of Mr. Ntaganda's order. And if there is a link, for sure, Mr. Ntaganda did not have the dolus directus of the 2nd degree, which necessitates that when issuing an order that is not criminal, he knows that the crime will be committed. Certainly, that was not the case, Mr. President. And the same applies to 25(3)(d), which is, of course, contributing in any other way. Once again, no common plan, then there should be no responsibility. But also, there was no mens rea. Let's assume, for the sake of argument, that the chamber finds that there was some kind of a meeting as described by P55. That's the evidence which we say is absolutely incorrect. But let's assume that we find that there was such a meeting. The mens rea requirement of knowing either the intention of that group to commit the crimes or to further the criminal activity of a group, or the intention of the group to commit the crime. The crime in Article 25(3)(d)(2) refers to a specific crime, just not there. And that is based on the worst possible evidence, which we say is unreliable. Mr. President, accordingly, there is no responsibility in our submission regarding the second attack as charged. A few words on command responsibility, Article 28. I will begin by the nature of Article 28 liability and address one of the arguments spelled out by my colleague yesterday or the day before. Mr. President, the nature of command responsibility is liability for failure to exercise command. Every time command responsibility, or most of the time command responsibility was used as a charge, it was because the commander did not have the applicable mens rea of the crime and was not involved in the actus reus of the crimes. I took part in many cases. Hadji Zanovich, there are other examples of persons charged with only command responsibility. That was before the ICTY. And these cases, because the prosecution made a choice, he's not involved, he's not a perpetrator, but he's a bad commander. So we will charge him according to 7.3 ICTY or Article 6.3 ICTR. Now, in this case, the prosecution, they want to charge him for a perpetrator, for an indirect perpetrator, for a direct perpetrator, for all kinds of perpetration, and also for being a bad commander. They just throw everything at the chamber and they say, let's find something, let's find a way to establish some kind of conviction. Are they allowed to do that? Yes, they are. The pretrial chamber said so. Pretrial chamber said if there is prima facie evidence, they can charge everything that they want. And they did. They did. But in assessing the evidence, it does show that the prosecution does not really know what Mr. Ntaganda is responsible for. All they know is that the internet says he's a bad guy and he should be convicted of something. Vertical chain of command. My colleague said yesterday, you go from the platoon commander to the company commander to the battalion commander and to the brigade commander, all of which can be found guilty pursuant to Article 28, command responsibility. My colleague is absolutely correct. That's the vertical chain of command. But what if you are outside the vertical chain of command? That was Mr. Ntaganda's situation, either de facto and de jure. Let's take a look at the organigrams that were submitted in evidence. In early November, let's focus on the position of Mr. Ntaganda, where he is not in that vertical chain of command. He is not a commander, he is a chef d'état-major général adjoint, opération et organisation. Let's look now at the Mongwalu operation. Well, here we see a difference. Here, we see that the overall commander is Kisembo, and in that vertical line, you have Bosco Ntaganda. That's a difference. We move to December, after Mongwalu. Well, Mr. Ntaganda rejoined what the position he had before, which is not in the vertical chain of command. Mr. Ntaganda did issue orders? Yes. Mr. Ntaganda did take measures to prevent? Yes. Mr. Ntaganda did take measures to punish? Yes. But all of these measures were taken pursuant to the authority of Floribert Kisembo, chef d'état-major général. And that is the same situation whether we look at it from a de jure point of view, the official appointment of Kisembo, Ntaganda, and the chef d'état-major général adjoint logistics, Dilango. And it's the same from a de facto point of view, and Mr. Ntaganda explained that in his testimony. Knowledge requirement. The only thing we say about this knowledge requirement is that what is the exact words in Article 28 must be interpreted as the test was for ICTY, because any other interpretation would be inconsistent with customary international law. We're not seeking to change the words. Should have known in Yamashita, everyone knows this is not customary international law, and this was rejected. That was should have known. At ICTY, they said, no, we can't do like Yamashita. So we will change that, and we'll say should have known. We'll say this really means the commander had reason to know, in the sense that he was put on notice of the need to investigate. At the ICC, we have should have known, but we added these words, owing to the circumstances at the time. We simply say that these words are simply another way to say the same test that was developed before the ICTY. Causal link is very important. My colleague mentioned yesterday or the day before that causal link did not exist, does not exist. And that causal link would be simply reading something into Article 28 that is not there. Well, first we say that is incorrect. You have before on the screen the reading of Article 28. And this reading clearly says that as a military commander or person effectively acting as a military commander shall be criminally responsible for crimes, ... as the case may be, as a result of his or her failure to exercise control properly. If that is not a causal link requirement, I don't know what that is, Mr. President. We're not reading anything new into the statute of the ICC. The drafter of the statute included the words, if crimes are committed as a result of lack of control, of failure to control, then Article 28 kicks in. When we look at the evidence in this case, and we look at the prosecution conceding 2 days ago that Mr. Ntaganda took all measures to prevent or repress other than for the crimes charged, then we say that the manner in which he exercised command in the evidence, if any crimes should be found to have been committed, they certainly do not result from his lack of control or from the manner in which he exercised control. So quickly we say that whether for the first attack or the second attack, we say that Mr. Ntaganda cannot incur liability pursuant to Article 28. In the first case, because of the absence of knowledge and measures taken. In the second case, because he did not have effective control. You've seen this one before, Mr. President. That's the end. You've seen it before. People know me for using this in every case I argue because I think it is very relevant. Mr. President, you see after 3 years of trial, we are able to make a difference. There are two ladies in this picture. The prosecution's case is the old lady. But if you look at the eye of the old lady, which is actually the ear of the young lady, and if you look at the chin and mouth of the old lady, which is actually the neck and the necklace of the young lady, that's the one that we have revealed and that we are confident the trial chamber will see once it analyzes all of the evidence on the record. There are two cases. I started by saying two visions based on the same evidence, but once we analyze the evidence, there will be only one conclusion, Mr. President. Mr. Ntaganda must be acquitted on all counts in the updated documents containing the charges. I end, Mr. President. I have 1 or 2 minutes left, I believe, simply to say that, as my colleague said yesterday, I think it applies probably more so to me. Mr. President, with all due respect, we've had a good match. Maybe before it's the color of our hair in the trial chamber. Mr. President, you won, and so should you. But there's been no knockdowns. Came close. When my colleague had to go to the hospital, and I also had to go for medical checkups, it came close, but there were no knockdowns. It was tough, but we say that this is what trials should be about. Mr. President, I wish to say that if at times like my colleague said, if at times I appear to be a bit argumentative, I apologize. It had never been the intention. The intention was always to fight for my client at all times, and that's what I think my team and I did. And I wish to acknowledge the work of my former co-counsel, Mr. Luc Boutin, who had to leave his duty because for medical. I was very lucky to have him replaced by a very experienced counsel, Chris Gosnell. I wish to say thank you to all members of my team and especially to all the interns There have been a number of interns rotating around. It's not easy. They come, they learn. Once they know, they go. But they all work very, very hard, and I wish to thank everyone on my team at the end of this case. Mr. President, thank you very much.
I also thank you very much, Mr. Bougon. So now we completed the closing statements, but according to our second order on closing statements, prosecution, if wishes so, may ask for opportunity to reply. Ms. Simpson, what is your position?
Yes, Mr. President, the prosecution does make a request to reply to the defense's submissions.
As we decided, you will have 30 minutes, and we will then now break for 30 minutes as well, and I guess you will be then ready to reply. Fine. Okay. So Mr. Bougon?
Maybe I should not say, it's my understanding that Mr. Ntaganda wants to make his unsworn statement, and pursuant to the decision, I think that Mr. Ntaganda will speak before the prosecution.
It depends, because, you know, it was a little bit unclear. It's up to you, in fact, because what we said, and be careful about that, Mr. Bougon, that we can't prohibit prosecution to reply to Mr. Ntaganda's, you call it, unsworn statement. So if you want to avoid that, then Mr. Ntaganda should wait until the very end of today's hearing. Am I clear enough? Because normally, if he would now take his right to make unsworn statement, then prosecution could even comment not only your closing statement, but also his unsworn statement. It was my understanding that you would like to avoid that. We can't prohibit prosecution to make it. So if you want to avoid prosecution to react on his unsworn statement, he still have a right to make it as a very last person. So a reply from prosecution, potential reply from defense team, and then as a last point, Mr. Ntaganda's unsworn statement. So what is your option?
Well, we'll hear the prosecution reply, and then Mr. Ntaganda will do his unsworn statement with the 30 minutes. Then if Mr. Ntaganda does not use his full 30 minutes, I'll use the rest to make sure that it is one defense.
It's not about time limits. Today we are at the stage of closing statement. It's the most important submissions for the case, so don't worry about the time.
Thank you, Mr. President.
So now, as we decided, prosecution we will now break for 30 minutes, and after at 11:35 we will resume, and prosecution will present their reply.
All rise. We will have a